The last topic in criminal law or crimes affecting business is cybercrimes. I'm going to talk briefly about cybercrimes, but I want to focus on defenses that are available to someone who has been accused of a crime. So the cybercrimes, I'm going to talk about cyber fraud, identity theft, phishing, hacking, cyber terrorism. These are examples of cybercrimes that affect business. So cyber fraud, what is it? Well, we've talked about a lot of fraud cases already. Here, it's the same definition. Any misrepresentation knowingly made, but in an online setting, with the intention of deceiving another for gain. So for example, Anthony selects 2 online auction sites and creates fake seller accounts on each. He creates an auction page on each for a rare antique clock, complete with a detailed description and photos. His minimum bid is $500. Clock sells for more on each site, so he sends the buyer a clock worth $50 and he sends the other one nothing and he claims the money. That would be a form of cyber fraud. Identity theft, stealing forms of ID and use it to get financial resources. Except in this case, somebody's using the internet, and identification could be just not a name, it could be date of birth, social security number, any personal information. Phishing, which is a form of identity theft. This is the sending out of electronic messages purportedly from some legitimate person or business to induce the recipient to reveal personal information. So phishing. You probably get a lot of emails from the college or business that are very much like this, and we get warnings from our IT departments. Hacking, using one computer to break into another, and this also includes breaking into mobile devices. Usually people are doing this to commit cyber theft or identity theft in some way. And then finally, the last one is cyber terrorism. This is one who exploits computers to create serious negative impact. For example, a computer virus attack, right, that goes through a company, disrupting a business, or even globally. When we think of cyber terrorism, we think, oh, it's going to affect the whole country. That is true, but also it can be business to business. Manipulate code entered into a processing control system of, let's say, a food manufacturer, which alters the level of ingredients so that consumers of the food become ill. That's an example of cyber terrorism. So cybercrimes, and cybercrimes is constantly being reviewed. Types of things that have occurred, and more laws are being passed to stop or prevent cybercrimes, more cybercrimes from growing as the need arises. So that completes our discussion on specific crimes, but now I want to talk about defenses. There are some defenses to criminal liability. Now here there are many defenses that can be raised that excuse a defendant or justify a defendant's criminal behavior. But primarily what we are going to be concerned with are the defenses related to white-collar crimes or business crimes. Like, I mean, we have the defense of self-defense, but that's usually not really in a business setting. It's when somebody's attacking another person and they need to defend themselves. Not going to talk about that here. I'm going to talk about the defenses that primarily relate to business crimes and white-collar crimes. And the first one generally is mistake, right? We have 2 forms. We have mistake of law and we have mistake of fact. Mistake of law is not a defense, meaning somebody cannot say that they didn't know a law existed. Ignorance of the law, right? They can't say they were mistaken by an idea of what the law required. That's not a defense. You can't claim a mistake of law, didn't know it was the law. However, sometimes mistake of fact can be a excuse to criminal responsibility, but that is if it negates the mental state necessary to commit the crime. That's the goal, is that when somebody is mistaken on a fact, they don't really have that mental state that we talked about. So for example, Julie mistakenly walks off with, oh, I should have another name there, huh? Let's say Mark mistakenly walks off with Julie's briefcase at a popular restaurant because he thinks it's his. Was there a crime committed? No, it was a mistake. If he realizes that it's not his and says, hey, this is a really nice briefcase, and continues to keep it, well, he's going to have some liability to Julie, right? He's got to return the briefcase. But it's not a criminal matter. It'd be something raised in a civil matter, which we'll talk about under torts. But here, because he was mistaken of a fact, he thought the briefcase was his, this would be a valid defense. John gives Mark a baggie and tells him it's cocaine and instructs him to bring it to Sandy in exchange for $1,000, and Mark does so. But Sandy is a CI and Mark is arrested for selling drugs. The substance turns out to be candle wax and not cocaine. Does Mark get off here? The answer is no, because he is not mistaken of the fact. He believes that it's cocaine. He was told that it was cocaine and his intent was to go and sell cocaine. The fact that the baggie contained candle wax is not going to get him off from prosecution. It may get him a different kind of charge, but it's not going to get him off. It's not going to be a defense to prosecution. Mark works at a bakery. John tells him to deliver the bag of flour that's sitting on the table next to the door to Darcy's bakery in the next town over and charge $50. So Mark does that. Darcy goes to bake some cupcakes an hour later, but the flour looks kind of weird to her. She sniffs it. She's kind of troubled that maybe it's not right. So she calls in her police officer husband to come and check it out. Sure enough, it is not flour, but it's cocaine, and Mark is arrested for selling cocaine. Does he have any defense here? Well, he can raise the defense of mistaken fact. He thought it was flour. He was told it was flour, and he was delivering flour. It wasn't his intent to sell drugs. So he does have a valid defense in this particular case. So mistake of fact, mistake of law. Mistake of law is not a defense, and mistake of fact could be a defense. Another defense is insanity. There are many different, each state has its own version of a definition of insanity. The idea is that somebody is suffering from some mental illness or mental defect. If somebody is incapable of establishing what we call the mens rea, or the state of mind, to commit a crime, then they lack capacity to appreciate the wrongfulness of the crime. So we can say that somebody has the defense of insanity. And this is a very complicated defense. And like I said, each state and the federal government has their own tests to what they constitute as insanity. But to give you an example of how it was used in a business sense, I actually used it in a case and was successful in the case. I represented a man who owned a used car dealership in Vermont, and he was traveling here to Plattsburgh, and he drove by a car dealer here, a used car dealer here, and saw a couple of cars sitting out in the lot that he wanted to have on his lot. So he went in and negotiated with the owner of that dealer for 2 cars. And in the course, the span of like a week's time, this takes place. He goes in, he does the negotiation, they swap out the cars, and it's not like as if we were going to go buy a car. Here's some money, give me the cars. There's a lot more contracts involved, and my client was getting money from his dealer, his banking, in order to get those cars. He ended up getting the cars, but the money did not exchange. He didn't ultimately end up paying for them because in the course of this exchange and happening, he fell ill. You can hear it in his voicemail message. He was diagnosed with bipolar, but he went very manic, and he was doing a lot of things that weren't deemed normal even in his own personal relationships. So his wife had him committed by a court. So a court directed, he didn't just admit himself. He was found to have a disability by a court and had to be committed for mental illness. But in the meantime, the car dealership in Plattsburgh is calling the police saying that this guy stole his cars. He was ultimately arrested for that. And for whatever reason, the case went all the way to trial, even though I had an enormous amount of proof that this guy had suffered from this mental illness during this period of time, including a psychiatrist that was going to come and say that. The case was still prosecuted, and in the end, the jury found that this person suffered from a mental defect and was not found guilty of it was grand larceny, number of grand larceny charges, high level because the cars were very valuable. So that's just an example of how this defense of insanity could work. Entrapment is another defense. What is entrapment? It's an act by which a public official, generally law enforcement, induces someone to commit a crime. Why do we have this? Well, it is a defense designed to prevent police officers and other government agents from encouraging crimes in order to apprehend persons wanted for criminal acts. So the undercover agent suggests that a crime be committed and somehow, pressures are induced an individual to commit an act. A typical scenario arises when law enforcement officers use coercion or other overbearing tactics to induce someone to commit a crime. The key component of entrapment is whether the person who committed the crime was inclined to commit the crime or did so only because the agent induced it. So the agent, law enforcement officer, resorts to behaviors such as threats, harassment, fraud, flattery to induce. There's this difference between what constitutes entrapment and what constitutes opportunity. The key aspect of entrapment is the government agents do not entrap defendants simply by offering them up an opportunity to commit crime. Judges expect people to resist any ordinary temptation to violate the law. So an entrapment defense arises when government agents resort to repugnant behavior. Just like I said in the last slide, threats, harassment, fraud, those types of actions. So, for example, Mary Ann Berry is charged with selling illegal drugs to an undercover police officer. Berry testifies that the drugs were for her personal use and that the reason she sold some to the officer is that at a party, the officer falsely said that she wanted some drugs for her mom, who was in a lot of pain. According to Berry, the officer even assured Berry that she wasn't a cop and wasn't setting Berry up. And the question is, does this constitute entrapment? Does this constitute entrapment? And the answer is no. This does not, right? Police officers are allowed to lie. The officer gave Berry an opportunity to break the law, but the officer did not engage in any extreme or overbearing behavior. Second example, Mary Ann Berry, charged with selling illegal drugs to an undercover police officer. Berry testifies that the drugs were for her personal use. For nearly 2 weeks, the undercover officer stopped by her apartment, pleaded with her to sell her some drugs from her stash, so because her mom was extremely sick and needed the drugs for pain relief. She says, I kept refusing. When the officer told her that the drugs would allow her mom to be comfortable for a few days, that the few days that she had left to live, Mary Ann said she broke down and sold her some drugs. And then she arrested Mary. And the question is, does this constitute entrapment? And the answer is yes, right? The undercover agent's repeated attempts and the lies, this is extreme, right? Sufficiently extreme to constitute entrapment. So here, the defense would work and Mary would be found not guilty. So this ends our discussion on criminal law and crimes affecting business.